The International Court of Justice. The International Court of Justice is also one of the organs of the UN as per Article 7 of the UN Charter. So you're going to see that with the International Court of Justice, it is provided, or it has actually a law or an act or a law, that is the statute of ICJ or the ICJ statute, but it stems from the UN Charter. So you see that by virtue of Article 92 and 93 of the UN Charter, they create the ICJ. Now, when they create the ICJ, we have to know what is the International Court of Justice. So this is the court that deals in resolving matters that are international in nature or that involve disputes between the members of the ICJ or even non-members, as we are going to see. So the ICJ, we have to know its composition. Like any court has composition. So the ICJ is composed of 15 judges. So it has 15 judges in number. And these judges are appointed by the General Assembly. Now, when a judge is appointed among the 15 judges of the UN Charter, of the ICJ, by the General Assembly, he sits in that office for a period of 9 years. So you work as a judge of the ICJ for a period of 9 years, but in total, it is composed of 15 judges. So the question is, what is the jurisdiction of the ICJ? Now, with jurisdiction of the ICJ, we have to look at the two kinds of jurisdiction it has. Actually, it has, I think, three kinds of jurisdiction. There is what we call jurisdiction in contentious matters. So the jurisdiction in contentious matters, this is where now the ICJ will have jurisdiction as per Article 36 of the ICJ statute. So here, this is where now there is a special agreement between the parties that, you know what, whenever there is a conflict, we shall refer the matter to the ICJ. So whenever there is a contention, you must have had a special clause in your agreement, you, the countries who are in conflict, that the court that will have jurisdiction in this matter shall be the ICJ. Then the other jurisdiction is the advisory jurisdiction. When you look at Article 65 of the ICJ statute, the ICJ has advisory jurisdiction. That is where now the ICJ is going to advise certain organs of the UN, such as the Security Council, the General Assembly, the Trusteeship Council, on certain matters. Basically, it just advises them. That is, it advises only the organs of the ICJ. So the organs of the ICJ, they will refer their matters to the ICJ. I mean, the organs of the UN will refer their matters to the ICJ to give advice. So it will have that advisory jurisdiction. Now the question is, what happens? Can someone raise a preliminary objection in the ICJ contesting its jurisdiction? Yes. Article 36, Clause 6 of the UN chart of the ICJ statute. Article 36, Clause 6 of the ICJ statute gives powers where you commence maybe a matter before the ICJ and I feel it lacks jurisdiction. I can raise a preliminary objection before the ICJ contesting its jurisdiction. And now the ICJ will have the power to entertain or to listen that objection and make a decision as to whether it has the jurisdiction or it does not have the jurisdiction. Now, when the ICJ is entertaining a matter, it has various powers, discretionary powers. It can grant provisional measures. These ones in the various municipal laws are known as the interim measures. Look at provisions of Article 41 of the ICJ statute. So that Article 41 of the ICJ statute will tell us that the ICJ has the power to give provisional measures, for example, injunctions, sanctions, among others, before even the matter is heard to its full entirety, in order to maintain the status quo. So it has that power to give interim remedies. Now, what happens where now, for example, country A sues country B, but there is a third party, not a party to the matter, that is involved or that is going to either be affected by the decision of the ICJ. So you're going to see that by virtue of Article 62 of the UN Charter, Article 62 of the UN Charter gives that third party to intervene at any stage of the proceedings and take part in the proceedings until that proceeding is fully decided. That is Article 62, meaning that where a conflict is between country A and B, but it is going to affect country C, country C is given chance to intervene in this matter until it is concluded by virtue of Article 62. Now the question is, can the ICJ give a judgment? Yes. The ICJ is like any other court. It can give a judgment. However, there are certain things that you have to know about the ICJ and its judgment. When you look at Article 60 of the ICJ statute, it gives the ICJ power to make a judgment. However, while it is giving a judgment, realize that there are 15 judges. It must be on the majority vote. That is, the judges must agree, vote yes. However, when it gives a judgment, its judgment is not appealable. So it is not appealable. So its judgment of the ICJ is not appealable. Now, when it gives a judgment, there are certain remedies it can give to a person. So we have to know the remedies of the ICJ, and these remedies include satisfaction, restitution, even compensation. Restitution, satisfaction, compensation, among other remedies, can be given to the person that has won the matter before the ICJ. Now the question is, how does the ICJ enforce its decisions? So the ICJ enforces its decisions under Article 94 of the UN Charter. And in Article 94, you realize we are told that all members of the UN have to comply with the decision of the ICJ, failure of which the Security Council will come in and enforce that decision. So basically, that is the ICJ. Thank you.